I'm here with David Reid, Director of Just Employment Law, to discuss the topic of holiday pay. Now David, we all remember the headlines from last year where it was announced that employees must be paid overtime included in their holiday pay entitlement. Can you tell me, have there been any developments since that announcement?
Yes, David. Since then there have been two important developments. The first development is that we now have a ruling on the question of whether commission needs to be included in holiday pay as well. And we also have some new legislation that's been introduced by the government to attempt to limit people's ability to claim back holiday pay against their employer over a long period of time.
Okay, so what has been decided in terms of commission payments?
Well, some people might remember that this whole revisiting of the holiday pay issue in the UK started with a case brought by a salesman from British Gas against his employer that he didn't have any of his sales commission included in his holiday pay. That case has now gone back to the Employment Tribunal in the UK, and the Employment Tribunal has decided that he should indeed receive his average earnings when he's on holiday.
Okay, and is this decision binding on other tribunals in the UK?
Well, technically it's not, David, because it's a first instance decision. However, we do have to remember that the European Court has said very clearly that employees should not be worse off while they're on holiday than they would be if they'd been at work during the same period. So it's very likely that other tribunals will follow this ruling.
Thanks, David. And do we have any certainty or clarification on what period employers should use when calculating employees' average earnings for the purposes of holiday pay?
No, we don't have any clarity on that yet, David. There's no binding ruling on that. A lot of employers are using a 12-week averaging period, which is already the law in the UK for people, for example, who do piecework. But there's nothing to say that a 12-week averaging period is the only one you can use. Potentially other periods and potentially much longer periods might be lawful as well.
So how would an employer go about deciding what averaging period to use?
I think the important thing is to look at the way your employees' earnings fluctuate over a period of time and to make sure that the averaging period you use gives a fair representation of what the employee would have earned had they been at work rather than on holiday for the period you're paying holiday pay.
So David, what has the government done in an attempt to limit employers' liability for backdated holiday pay claims?
Well, the government's introduced a new law, David, that will come into effect at the start of July this year that says where an employee does bring a claim for backdated holiday pay against their employer, they can only go back for a maximum period of 2 years with that claim.
Okay, and is this law specifically aimed at limiting holiday pay claims only?
Well, that's why the law was brought in, David, but the way it's been done actually means that it will cover all claims for what's known as unlawful deductions from wages.
So what about claims that are already in the Employment Tribunal system prior to July? What will happen to those?
Well, these claims are not subject to this statutory 2-year limit, but when the big holiday pay claim was decided by the Employment Appeal Tribunal back in November last year, the way it structured its ruling on time limits means that it's actually quite difficult for people to go back as far as 2 years anyway.
Thanks, David. You made reference to the big holiday pay case. Now remind us, what did that case determine in respect of holiday pay claim time limits?
Well, that case determined that where the gap between different underpayments of holiday pay was more than 3 months apart, that broke what's called the series of unlawful deductions from wages, and it meant that employees couldn't go back any further than that with their claims.
Okay, and where employers afford employees holidays in excess of the statutory minimum entitlement, do they have to calculate holiday pay based on average earnings for all such entitlement?
Well, the case law now seems pretty clear that the right to be paid average earnings for your holiday pay only applies to the first 20 days or 4 weeks that employees are entitled to under the Working Time Directive. If employers give additional entitlement beyond that, it might be possible to pay that at basic pay. So one question employers are going to have to determine at the moment is whether they want to have two systems where some holidays are paid at average earnings and some are paid at basic pay, or whether they're going to pay all of the holidays at average earnings.
Okay, thanks David. And are there any unanswered questions that await clarification via test cases in respect of holiday pay?
Yes, I think there are, David. I think there are at least 3 important questions that still need to be answered. The first one is whether genuinely voluntary overtime needs to be included in holiday pay calculations. We don't know the answer to that yet. Secondly, we don't know yet what types of bonuses need to be included in holiday pay calculations. And thirdly, we don't really have any guidance on what different averaging periods might be lawful when calculating holiday pay. I think in all of these areas, employers would benefit from some guidance from the higher courts.
Okay, thanks David. And finally, your headline advice, if you will. What should employers be doing now in terms of holiday pay?
Well, there's no one right answer for all employers in this situation, David. If you decide to wait and see a little bit longer, if you haven't made any changes yet, then certainly it's possible that you'll accrue some further and fairly significant liabilities to your employees in respect of holiday pay. You might take some comfort from the fact that claims can only go back 2 years from July onwards if you haven't had claims brought against you already. But it's fair to say that taking no action at all is quite a risky strategy for employers at the moment. For employers that do want to take some action and introduce a new holiday pay scheme, the important thing will often be the timing of introducing the new scheme. And in relation to that, it would be highly advisable for these employers to take some specialised legal advice on this issue before bringing their new scheme into effect.
Thanks, David.
Thank you.